Hello friends, welcome to Prashant IAS. So friends, in the last class, we have discussed about the preamble to the Constitution of India. And in this class, we will start our discussion with the fundamental rights. So, let's begin. So friends, fundamental rights are given in the Part 3 of the Indian Constitution. And Article 12 to 35 deals with the fundamental right. Okay, so in which part fundamental rights are given? So fundamental rights are given in Part 3 of the Indian Constitution. And which articles deals with the fundamental rights? So Article 12 to 35 deals with the fundamental right. Okay, so fundamental rights are given in Part 3 of the Indian Constitution and fundamental rights are given in Article 12 to 35. Now friends, America was the first country. America means USA, United States of America. So USA was the first country to include certain basic rights in the Constitution. Okay, so America was the first country to include certain basic rights in the Constitution, and these were known as Bill of Rights. Okay, so America was the first country to include certain basic citizen rights in the Constitution of the country, and these were known as the Bill of Rights. And later on they came to be known as fundamental rights. Okay, so America was the first country to provide fundamental rights to its citizens and to include these rights in its constitution. Now friends, in the previous lectures, I have told you that we have adopted the concept of fundamental rights from the Constitution of USA. So now what does it mean? So it means that we get inspiration to include fundamental rights in our Constitution from the Constitution of USA. Now what does it mean? So it means that fundamental rights were there in the Constitution of USA. So we got inspiration from the Constitution of USA and we also included fundamental rights in our Constitution. Okay, so we get inspiration to include fundamental rights in the Constitution of India from the Bill of Rights in the Constitution of USA. Now friends, in the Karachi session held in 1931, fundamental rights were demanded for Indian citizens for the first time. Okay, means Indian people. So in 1931, in Karachi session, fundamental rights were demanded for Indians for the first time. Okay, now friends, let's move further. So friends, now the question arises that why these rights are called as fundamental rights. Okay, so as we are discussing about the fundamental rights, so this is our first duty to understand that which rights are known as fundamental rights and why these rights are specifically known as fundamental rights. So now let's discuss that why these rights are called as fundamental rights. So friends, the first reason is that these rights are guaranteed by the fundamental law of the land. Okay, so these rights are guaranteed by the fundamental law of the land. And what is the fundamental law of the land? Constitution is the fundamental law of the land. And these rights are guaranteed by the Constitution, means the fundamental law of the land, and that's why these rights are known as fundamental rights. Okay, so as these are guaranteed by the fundamental law, that's why they are known as fundamental rights, means they are guaranteed by the basic law, so they are known as basic rights. Okay, so fundamental rights are called as fundamental rights because they are guaranteed by the fundamental law of the land. So this is the first reason. Now what is the second reason? So friends, the second reason is that state cannot take away them, means state do not have the authority to take away these rights from the citizens of the country. Now what does it mean? So we know that, for example, legislature is we know that there are three organs of the government: legislature, executive and judiciary. So friends, executive do not have the power to take away these rights from the citizens. Executive is not allowed to do anything. Executive is not allowed to take any administrative action which violate these fundamental rights or which abridges these fundamental rights. Abridges means reduce the value. Okay, so the executive wing of the government is not allowed to do anything which takes away the fundamental rights of the citizens, or which reduces the value, which reduces the effect of the fundamental rights of the citizens. Okay, so the executive wing of the government is not allowed to do anything, to do any administrative thing which takes away or which reduces the effect of fundamental rights. And if executive will do any such thing, then that action of the executive will be declared invalid by the court. Now friends, what is the second meaning of this? Its second meaning is that the legislative wing of the government means parliament and the state legislatures. So parliament and state legislatures are not allowed to make any law which takes away or reduces the effect of any fundamental right. Okay, so parliament and state legislatures are not allowed to make any law, to make any regulation which takes away or reduces the value of any fundamental right. And if parliament or any state legislature will do so, then that law will be declared null and void by the Supreme Court of India. So what does it mean? So it means that any law cannot violate them. Okay, so any law means whether it is a pre-constitutional law or it is a post-constitutional law, no law can violate any fundamental right. So what is a pre-constitutional law? So pre-constitutional law means laws which were made before the commencement of the constitution. For example, IPC, Indian Penal Code. Okay, so laws which were made before the commencement of the Indian constitution, if they violate the constitution, then these laws will be declared null and void by the Supreme Court. And post-constitutional laws means laws which are made after the commencement of the constitution, means after the making of the constitution. So the laws which are made after the commencement of the constitution, if they violates any of the fundamental right, then these laws will again be declared null and void and invalid by the Supreme Court of India. So what does it mean? It means that state do not have the power to take away or reduce the effect of fundamental rights. Okay, legislature cannot make any law which reduces the effect or which takes away any fundamental right. Executive cannot do anything which takes away the fundamental right or which reduces the value of fundamental right. Okay, and any law which was made before the commencement of the constitution, if it violates one or more provision of the fundamental right, then that law will be declared null and void. And if a law which is made after the commencement of the constitution, if it violates one or more provision of the fundamental right, then that law will also be declared null and void. So what does it mean? It means that executive wing of the government cannot violate fundamental right, legislative wing of the government cannot violate fundamental right, any pre-constitutional law cannot violate fundamental right, any post-constitutional law cannot violate fundamental right. So these rights are very, very protected by the Constitution of India, and that's why also these rights are known as fundamental rights. Means these rights are placed over executive wing of the government, they are placed over legislative wing of the government, they are placed over any of the pre-constitutional law, they are placed over any of the post-constitutional law, and that's why they are fundamental in nature. Means they are very basic in nature. Now what is the fourth reason? So friends, they are most essential for the all-round development of any individual. Okay, so these rights are very, very essential for the all-round development of any individual. So all-round development means physical development, intellectual development, and spiritual development. Now what does it mean? So it means that without these rights, it is not possible for any individual to attain his physical development, intellectual development, and spiritual development. So if any individual wants to attain his physical, spiritual, and intellectual development, then these rights are very, very important for him. So let me explain you this with the help of an example. So friends, for example, we all know that Article 21 is right to life and personal liberty. Now suppose there is no Article 21. So if there were no Article 21, then everyone will think that his life is in danger. Because what Article 21 does? Article 21 guarantees you the right to life and personal liberty. And without Article 21, your life is always at risk. So suppose if there was no Article 21, then everybody would think that anybody can kill me, my life is in danger. And now suppose if you are thinking 24 hours, 7 days that your life is in danger, you have to protect your life, anybody can kill you. okay, even state can kill you, then will you be able to give time to your intellectual development? Definitely not. Will you be able to attain your physical development? Will you be able to attain your spiritual development? Definitely not. Why? Because every time you are in the fear that your life is in danger, anybody can kill you. So when you are in the fear that anybody can kill you, every time you are doing something to protect your life, when you are in the fear that anybody can kill you, then in that situation you can even go in depression. Why? Because every time you have the fear of the loss of life, so you can even go in depression. So in depression, can you do your intellectual development? Can you do your physical development? Can you do your spiritual development? Okay, so when you do not have the guarantee of your life, okay, when you are not assured that your life is secured, when you are always doing something to protect your life, will you be able to spare the time for reading the books, okay, for doing meditation, for doing physical exercise? No, you will always be busy in protecting your life. But friends, now imagine, or it is the current situation in India that we have Article 21, means state constitution guarantees to us right to life and personal liberty. Means our life is secured. We do not have the tension that our life will be lost. Okay, state cannot take away our life. Any individual cannot take away our life. Okay, and if anybody will harm us, then he will be punished by the court of law. So we have the guarantee that our life is guaranteed by the state. Our life is guaranteed by the constitution. So we do not have any fear that our life is at threat. So now, when you are fearless, when you do not have fear, when you do not have fear, when you have guarantee, when you are assured that your life is secured, then definitely you can easily spare the time to read the books. Okay, to read the novels, and by reading the books, by thinking, you can do your intellectual development. You can easily spare the time to do exercise, running, swimming, and by doing these all physical exercises, you can do your physical development. You can easily spare the time. You can happily do meditation, and by doing meditation, you can do your spiritual development. Okay, so all the fundamental rights are very, very important for the physical, intellectual, and spiritual development of any individual. And physical development, intellectual development, and spiritual development, they are definitely the fundamental needs of any human life, and that's why also these rights are known as fundamental rights, because these rights are very, very essential for all-round development of any individual. So these rights are known as fundamental rights. So friends, these were the 4 reasons that why these rights are known as fundamental rights. So first reason is that they are guaranteed by the fundamental law of land. Second reason, state cannot take away them. Third reason, any law cannot violate them. Fourth reason, they are most essential for all-round development of any individual. So these rights are known as fundamental rights. Now friends, these rights are also known as the cornerstone of Indian democracy. Now what does it mean? So it means that these rights are very, very important for the healthy functioning of Indian democracy. Okay, so these rights are very important for the healthy functioning of Indian democracy. Now friends, to make you more clear about fundamental rights, let us compare fundamental rights with ordinary legal rights. Okay, so after this comparison, you will get more clarity about what are fundamental rights, or what is the value or force in fundamental rights. So friends, on left side we have ordinary legal rights, and on the right side we have fundamental rights. So friends, ordinary legal rights are provided and enforced through the ordinary law of land. So ordinary law of land means any law passed by the parliament by a simple majority. Simple majority means more than 50% of the members present and voting. Okay, so ordinary law means law which is ordinary right means a right which is provided and enforced through ordinary law of land. So ordinary law of land means any ordinary law which is passed by parliament or any state legislative assembly. Now what are fundamental rights? So friends, fundamental rights are provided and guaranteed by the constitution. So fundamental rights are not guaranteed by the ordinary law of land. Fundamental rights are provided by the Constitution of India, and fundamental rights are guaranteed by the Constitution of India. Okay, and we all know fundamental constitution is the fundamental law of the land. Constitution is the first law of the land. Constitution is the basic law of the land. Constitution is the supreme law of the land. So definitely fundamental rights are provided by the constitution, and they are guaranteed by the Constitution of India. Now friends, what is the second difference? So friends, if you want to change the ordinary legal right, okay, so in order to make any change or amendment in the ordinary legal right, ordinary process of lawmaking is sufficient. Okay, so only ordinary process of lawmaking can change any ordinary legal right. So what is ordinary process of lawmaking? So we know that ordinary process of lawmaking is simple majority. And what is simple majority? Simple majority means more than 50% of the members present and voting. And simple majority can easily be attainable. Okay, it can easily be attained in parliament or in any state legislative assembly. Okay, so if you want to change any ordinary legal right, then ordinary process of lawmaking can change any ordinary legal right. And what is ordinary process of lawmaking? Ordinary process of lawmaking means a simple majority of more than ordinary process of lawmaking means simple majority. And what is simple majority? Simple majority means more than 50% of the members present and voting. So this is simple majority. But friends, if you want to amend the fundamental rights, okay, then ordinary process of lawmaking will not work. Ordinary process of lawmaking is useless. Simple majority is useless. Okay, so in order to amend the fundamental right, the process of amending the constitution comes into use. Okay, so how to amend fundamental rights? Fundamental rights are amended by the process of amending the constitution. And what is the process of amending the constitution? So I have told you in previous lectures also. So if parliament wants to amend the constitution, then how parliament can do so? Then parliament needs a special majority of more than 2/3 of the members present and voting, which should be more than absolute majority of the house. Okay, so what majority is needed to amend the constitution? So a special majority of more than 2/3 of the members present and voting, which should be more than absolute majority of the house. And this type of majority is very, very difficult to be attained in the house. Okay, so the amendment process of the fundamental rights is very, very difficult. Okay, so fundamental rights can only be amended by the process of amending the constitution, and it is the special majority of more than 2/3 of the members present and voting, which should be more than absolute majority of the house. And this type of majority is very difficult to be attained, and that's why fundamental rights are much, much protected than the ordinary legal rights. So if parliament wants, then parliament can easily change any ordinary legal right, but parliament cannot easily change fundamental right. Parliament has to attain a special majority of more than 2/3 of the members present and voting, supported by the at least absolute majority of the house. Now friends, what is the third difference? So friends, on the violation of any ordinary legal right, you can only file a case in subordinate court or at most high court. Okay, so suppose if your ordinary legal right is violated, then you can approach ordinary court. Ordinary court means lower court, district court, okay, subordinate court. Okay, so if your ordinary legal right is violated, then you can approach subordinate court. Subordinate court means lower court, district court, or at max means maximum you can approach high court. You can file a case in high court. But friends, if your fundamental right is violated, then person can directly approach Supreme Court. Means if your fundamental right is violated, then you can file a case against who has violated your fundamental right in the Supreme Court of India. Okay, so Supreme Court of India is the protector of fundamental rights. So if your fundamental right is violated, then you can directly file a case in the Supreme Court of India, and then you will get relief from the Supreme Court of India. So definitely you can see here the level of protection which is provided to fundamental rights, that ordinary legal rights have very less protection, but fundamental rights have very high level of protection. Ordinary legal rights are enforceable by subordinate court, high court, but fundamental rights are enforceable directly by the Supreme Court. Okay, so what are ordinary legal rights? So ordinary legal rights are provided and enforced through ordinary law of land, and if parliament or any state legislature wants to change them, then ordinary process of lawmaking is sufficient. And on the violation of ordinary legal rights, you can file a case only in subordinate court or at max in high court. But fundamental rights are those rights which are provided and guaranteed by the constitution. And if parliament, okay, state legislatures do not have the power to amend fundamental rights. Only parliament has the power to amend fundamental rights. And even parliament can amend fundamental rights by the process of amending the constitution. And process of amending the constitution is very, very difficult. Means fundamental rights are very, very protected. And if your fundamental rights are violated, even even though if central government has violated your fundamental right, then also you can directly approach the Supreme Court. You can directly file case against central government in Supreme Court, okay, and Supreme Court will give you relief, okay. So Supreme Court is the protector of fundamental rights. So friends, now I hope that you all must have understood that what are fundamental rights, okay. So fundamental rights have a very good level of protection. They are highly protected right, okay, and they are directly protected by the Supreme Court of India. Now friends, let's move further. So friends, now question arises that why certain rights are declared as fundamental rights. Okay, so now we know what are fundamental rights, okay, why these rights are called as fundamental rights, what is the difference between fundamental rights and ordinary legal rights. But now the question arises that why certain specific rights are declared as fundamental rights, okay, and this is the thing which we should know. So friends, according to the Supreme Court of India has observed that the purpose of enumerating fundamental rights in the Constitution is to safeguard the basic human rights from the vicissitudes of political controversy and to place them beyond the reach of political parties who, by the virtue of their majority, may come to form the government at center or at the state. Okay. So what Supreme Court has observed? So Supreme Court has observed that the purpose of enumerating the fundamental rights in the Constitution is to safeguard the basic human rights from the vicissitudes of political controversy and to place them beyond the reach of political parties who, by the virtue of their majority, may come to form the government at center or at the state. Now friends, this statement is very technical, okay, and it is also very difficult to understand. So now I will make you understand this statement but with the help of an example, okay. So I will give you one example so that you can understand this statement very clearly. Now friends, we all know that there is party politics in India. So party politics means there are many political parties. For example, BJP is a party, Congress is a party, Communist Party of India, Aam Aadmi Party, and similarly there are many parties in India, okay, and these parties finally forms the government, okay. So I have also told you that how government is formed. So I have told you that suppose in 2019 there were Lok Sabha elections, okay. So the party which got more than 50% of the seats, more than 50% of the total membership of the house, okay. So a party who get more than 50% of the total membership of the house, okay, more than 50% of the total membership of the house, that party will form the government, okay. So now we know that there are 543 total seats in Lok Sabha, okay, and the 50% of 543 is 271.5. So more than 271.5 means 272. So the party who will have at least 272 seats or more than that in Lok Sabha will form the government, okay. So who will form the government? The party who will have at least 272 or more than that seats will form the government. Now friends, I will not take the name of any political party here. We will imagine hypothetical parties to understand this concept. So suppose there are 4 political parties, Party A, Party B, Party C and Party D. So there are 4 political parties. Now friends, imagine Party B got 280 seats in Lok Sabha, okay. Other parties also have some seats. For example, Party A have 40 seats, Party C have again 50 seats, okay. But Party B got 280 seats in Lok Sabha. Now to form the government, at least 272 seats are needed and 280 is a number which is higher than 272. So definitely you can say that, sir, now Party B will form the government. Now suppose Party B formed the government, the leader of Party B became the Prime Minister and other members of Party B from Lok Sabha and Rajya Sabha became the other ministers. So Party B formed the government. Now friends, we know that to form the government, absolute majority is needed. What is absolute majority? Absolute majority means more than 50% of the total membership of the house, and this majority is needed to form the government, and absolute majority in Lok Sabha is 272, okay, and the party got 280 seats, means party has more than official absolute majority. Now friends, any party who is having absolute majority in Lok Sabha, it is very easy for that party to gain simple majority. Why? Because what is simple majority? Simple majority means more than 50% of the present and voting. Okay, more than 50% of the members present and voting. So simple majority is, so please listen to me carefully. What is simple majority? Simple majority means more than 50% of the members present and voting. And what is absolute majority? Absolute majority means more than 50% of the total membership of the house. Okay. So what is more? Definitely absolute majority is more difficult. So party who is having absolute majority, it is very easy for that party to gain simple majority in the house. Now suppose friends, party B is having absolute majority. Definitely party B is having 280 seats, so it is having absolute majority. Now it is very easy for party B to gain simple majority in the house. And friends, I have told you that simple majority is needed to make any ordinary law. Okay, so it is very easy for the party B to make any ordinary law. Okay, now suppose one condition that these rights are not guarantees to us as fundamental rights. Means these rights, if these rights were not included in the constitution. So if these rights were not included in the constitution and these were not guarantees to us as fundamental rights, then definitely parliament could have parliament could have amended them via ordinary process of lawmaking. Okay, ordinary process of lawmaking means simple majority. And I have told you that the majority party means party B can easily gain simple majority in the house because party B is already having absolute majority. That's why it formed the government. Okay, so now suppose friends, the ideology of party B is orthodox. Orthodox means it is not liberal. It is more aligned toward ancient practices, ancient beliefs. Okay, and party B does not believe in the freedom of human being. Party B does not believe in the liberty of individual. Okay, so now what is the ideology of party B? The ideology of party B is that party B does not believe in the liberty of individual. So now what party will do? Definitely party B will try to limit the liberty of individual, and we all know that Article 19 guarantees to us freedom. Okay, Article 19 guarantees to us right to liberty or right to freedom. So now what is the aim of party B? So the very basic aim of the party B is to remove Article 19, means right to freedom from the constitution. Okay, so now suppose friends, if right to liberty was not a fundamental right, means right to liberty was not included in the Constitution of India, so at that point of time party B can easily remove it with the help of simple majority. And it is very easy for party B to get simple majority because it is already having absolute majority in the house. So someone having absolute majority, it is very easy for him to get simple majority. Okay, so if right to liberty was not a fundamental right, if right to liberty was not included in the Constitution of India, then party B can easily remove, can easily take back, can easily reduce the effect of right to liberty. Why? The simple majority. Why? Because it is very easy for party B to get simple majority. But what is the current practice? The current practice or the current situation is that Article 19 is a fundamental right. Article 19 is included in the Constitution of India. So if party B wants to amend, if party B wants to remove Article 19, then party B has to do this by the process of amending the Constitution. And what is the process of amending the Constitution? For amending the Constitution, a special majority of more than 2/3 of the members present and voting, which should be supported by at least absolute majority of the house. This type of majority is needed. Okay, so which majority is needed to amend the Constitution? A special majority of more than 2/3 of the members present and voting, which should be more than absolute majority of the house. That this type of majority is needed. And friends, it is practically very, very difficult for any political party to get this type of majority. Why? Because party B is having 280 members, but the number is much higher than that. Okay, the number which is needed for constitutional amendment is much higher than that. So if party B wants to remove right to liberty, if party B wants to remove right to liberty from the list of fundamental rights, then party B also needs the support of party A, party C and party D, and Only when party A, party C and party D will support party B, then only party B will be able to remove right to liberty from the fundamental rights. Okay, and party A, party C and party D, they are actually opposition parties, so they will not support party B, they will not support party B always. They will only support party B when there is a very very special need, when there is a very urgent need to remove or to add something in the fundamental rights. Okay, so the meaning of this statement is that the fundamental rights are placed beyond the power of political party. They are placed beyond the they are placed beyond the majorities which political parties have. They are placed beyond the controversy of political parties. Okay, so the meaning of this statement is that a single political party which is having a absolute majority in Lok Sabha, it is not allowed to amend the fundamental rights. It do not have the power to amend the fundamental rights for its greed, for its own ideology, for its own self. Okay, so any one political party who is having absolute majority in Lok Sabha is not allowed to amend any fundamental right, to take away any fundamental right from the citizens, to take away any fundamental rights from the people of a country. If actually there is a need to amend any fundamental rights, then the support of all the parties is needed, and only when all the parties will support, then only the fundamental right can be amended. So the very basic meaning of this statement is that the fundamental rights, the basic rights of the people of India, of the citizens of India, are placed beyond the reach of political parties. Okay, they are placed beyond the reach of political parties. They are placed beyond the controversy of political parties. Means a single political party who is having absolute majority in Lok Sabha is not allowed to make any change in fundamental rights. A single political party, for its own selfishness, for its own ideology, cannot amend or change any fundamental right. Okay, now friends, this statement is very very important. It is the statement given by the Supreme Court of India. And friends, you will rarely find this statement in any book. Very few books mentions this statement, and I think no teacher in India teaches this statement. So if you will include this statement in your mains answer, okay, so if you will find any mains question, IAS mains question regarding fundamental rights, and if you will include this statement, then definitely you will fetch extra marks. And if there is something in essay related to fundamental rights, okay, if you are writing your essay and in your essay there is something related to fundamental rights, and if you use this statement there, then definitely this will attract the examiner and he will definitely give you extra marks. So I recommend you all to use this statement smartly in your mains answer writing. Now friends, let's move further. So friends, fundamental rights provide protection to the citizens and the people of a country, mostly against the action of the state. Okay, so fundamental rights provides us protection from the action of the state. Okay, for example, state cannot take away our life, or state cannot reduce our personal liberty, only except according to the process established by the law. Okay, so fundamental rights are mostly against the action of the state. Fundamental rights provide protection to the individuals against the action of the state. Okay, for example, if you see Article 21, so state is not allowed to take away the life of any individual. State is not allowed to take away the liberty of any individual except according to the process established by the law. Means Article 21 stops the state from killing any individual. Article 21 stops the state from imprisoning any individual. Okay, so what is Article 21? So Article 21 is guaranteed to us against the action of the state. Now friends, only in some cases fundamental rights provide protection against the action of the individual. For example, right against untouchability. So no individual in India can practice untouchability. No one can declare you untouchable. No one can practice untouchability with you. Okay. And for example, right against exploitation. So no one is allowed to exploit your life. No one is allowed to exploit you. Okay. So only some rights are given against the actions of individual. Mostly all the fundamental rights are guaranteed to us against the action of the state. Now friends, fundamental rights are not absolute, they are qualified. Now what does it mean? So it means that almost every fundamental right is subject to some reasonable restrictions. For example, we have Article 19. So Article 19 clause 1 subclause A gives us a right to freedom and freedom of speech and expression, means we can speak whatever we are thinking. Okay, so Article 19 clause 1 subclause A guarantees to us freedom of speech and expression, means we can speak anything which we are thinking, we can speak anything in public. But friends, there are certain restrictions also. For example, you cannot speak anything in public, you cannot speak anything which can affect the relationship of India with other foreign countries. Okay, so you cannot speak anything, you are not allowed to speak anything which affect the relationship of India with any other foreign country. So there are reasonable restrictions on almost every fundamental right. So no fundamental right is absolute. Okay, all fundamental rights are qualified. Now friends, fundamental rights are grouped into two categories. Negative injunctions, for example Article 14, Article 15 clause 1, Article 16 clause 2, and positive injunction. Positive injunctions means Article 16 clause 1, Article 19, Article 25. So what is the meaning of negative injunction? Negative injunction means negative commandments on the state. Means state is stopped from doing certain actions. For example, state cannot do this, state cannot do this. Okay, so negative injunctions means fundamental rights stops state from doing certain tasks. This is negative injunctions, means state cannot do this. And positive injunctions means positive commandments, means fundamental rights are giving command to state to do certain tasks. For example, state should do this, state should do this. For example, in Article 19, state has to provide freedom of speech and expression to all the individual. Okay, state has to guarantee right to liberty to all the citizens of India. Okay, so there are two categories of fundamental rights, negative injunctions, and in negative injunctions fundamental rights are stopping the state from doing certain tasks, and in positive injunctions fundamental rights are giving command to state to do certain task. Now friends, let's move further. So friends, then come the doctrine of eclipse. And in order to study doctrine of eclipse, first of all we have to study Article 13 clause 1. So what is Article 13 clause 1? So Article 13 clause 1 says, pre-constitutional laws inconsistent with the fundamental right shall be void. Now what does it mean? So it means that all the pre-constitutional laws which were enforced immediately before the commencement of the constitution, if they violate one or more fundamental right, then they shall be invalid and void to the level of inconsistency. Okay, so all the pre-constitutional laws which were enforced immediately before the commencement of the constitution, if they violate one or more fundamental right, then they shall be invalid and void to the level of inconsistency. Now what does it mean? So I will explain you it with the help of an example. So friends, suppose we know that there are many laws which were enforced before the commencement of the Indian Constitution. For example, IPC. So Indian Penal Code was enforced much before the commencement of our Constitution. So now suppose there is some specific provision in the IPC which violates any fundamental rights. Suppose it violates right to life. Okay, so if there is some provision in IPC which violates any fundamental right, then that specific provision of IPC will be declared unconstitutional and invalid by the Supreme Court of India. Okay, so the entire law will not be declared invalid. Only those provisions of the law will be declared invalid who will violate the fundamental rights. Okay, so entire law will not be declared invalid. Only those provisions will be declared invalid who will violate the constitution. Okay, so all the pre-constitutional law means the laws which were made before the commencement of the constitution. If they violate one or more fundamental right, then these laws will be declared invalid and void. Okay, these laws will be declared invalid and void to the level of inconsistency, means those provisions will be declared invalid who violate the fundamental right. Now friends, then what happens, that then comes the Bikhaji Narayan versus State of Madhya Pradesh case 1955. And what happens in Bikhaji Narayan versus State of MP case 1955, that Supreme Court applied the principle of eclipse. Now what is this principle of eclipse? So Supreme Court said that pre-constitutional law violating the fundamental right can be made dormant. So what Supreme Court was saying? Supreme Court was saying that laws which were made before the commencement of the constitution, okay, so means laws which were made when constitution was not there, so these laws were not invalid ab initio, means these laws were not invalid, these laws were not invalid from the very beginning, okay. So what Supreme Court was saying? Supreme Court was saying that these laws which were made before the commencement of the constitution, these were not invalid from the very beginning. When these laws were made, at that point of time there was no constitution, so these laws were valid, okay. So Supreme Court said that these laws were not valid from the very beginning, and that's why it is not the fault of these laws, okay, it is not the fault of these laws that after their making constitution was made and now they are invalid. So what Supreme Court was saying, that these laws should not be dead, means these laws should not be killed, these laws will be made dormant. Dormant means the law will be in existence but law will be stopped to work. Law will exist but law will sleep, okay. So dormant means law will not be killed, law will not be dead, law will sleep, and law will not be allowed to work, okay. So it means that these laws will be placed in the shadow of fundamental right, and if in future any constitutional amendment is able to remove the conflict between the law and the fundamental right, then again these laws can be revived again, means then these can be put to work again. Okay, so what is principle or doctrine of eclipse? So doctrine of eclipse says that any pre-constitutional law which violate one or more fundamental right, it will not be declared dead, it will not be killed. So what Supreme Court will do with that law? Supreme Court will make that law dormant, means that law will sleep, okay, that law will not work but it will remain in existence, so that law will become dormant. Dormant means it will come in the shadow of fundamental right, it will not work, it will sleep, it will made dormant, okay. So it will come in the shadow of fundamental right, and if in future any amendment is able to remove the conflict between the law and the fundamental right, then that law can be revived again, means then that law can be put to work again, because what is happening, that Supreme Court is stopping that law from working, okay. So and if in future the conflict is removed, then that law can be put to work again. So this was doctrine of eclipse. So doctrine of eclipse says that any good law, any good pre-constitutional law should not be declared dead, it should not be killed, okay, it should be declared dormant. Dormant means it is safe in the shadow of fundamental right, it is not working until fundamental right is working, okay, it is actually sleeping. And if fundamental right, if the conflict is removed in near future, if the conflict is removed in future, then that law can be revived again. Now friends, then comes the Deepchand versus State of Uttar Pradesh case 1959. So what happened in Deepchand versus State of UP case 1959? So Supreme Court said that only doctrine of eclipse can only be used to protect pre-constitutional law. Means according to doctrine of eclipse, only pre-constitutional law will be declared dormant. Means they will be kept in the shadow of fundamental right. Means they will not be declared dead, they will not be killed, they will be declared dormant, they will be kept in the shadow of fundamental right. So what Supreme Court said, that according to doctrine of eclipse, so doctrine of eclipse can only be used to protect pre-constitutional laws because these laws were not invalid from the very beginning. But post-constitutional laws means laws which were made after the commencement of the constitution, these laws were invalid ab initio. Means these laws were invalid from the very beginning because constitution was already commenced. So laws which were made after the commencement of the constitution, they were invalid from the very beginning, and that's why they do not deserve any protection under the doctrine of eclipse. So these laws will be declared invalid, void and dead. Okay, so these laws will be dead, they will be killed, and in future they cannot be revived again. Now friends, then comes Amika Mill versus State of Gujrat case 1974. So in Ambika Mill versus State of Gujrat case 1974, Supreme Court overruled its decision, and what Supreme Court said, that doctrine of eclipse can be used to protect both pre-constitutional laws as well as post-constitutional laws. Okay, so in Ambika Mill versus State of Gujrat case 1974, Supreme Court overruled its earlier decision, and Supreme Court said that doctrine of eclipse can be used to protect pre-constitutional laws, means laws which were made before the commencement of the constitution, and doctrine of eclipse can also be used to protect good post-constitutional laws, means laws which were made after the commencement of the constitution. Now friends, let's see whether the fundamental rights are amendable or not. Okay, so let's check the amendability of the fundamental rights. So friends, Article 13 clause 2 says that state shall not make any law that takes away or abridges one or more fundamental right. So take away means that state totally ends that fundamental right. State totally snatches that fundamental right from the citizen, and abridges means reduces the effect of that fundamental right. Okay, so Article 13 clause 2 says that state is not allowed to make any such law which takes away or which reduces the effect of one or more than one fundamental right. Okay, so friends, what is the meaning of state here? Okay, so friends, the meaning of state here is little bit different for the purpose of fundamental rights. The state has been defined in a wider sense. Okay, so here the meaning of state is little bit different. So what is the meaning of state? It is defined under Article 12. So according to the Article 12 of the Constitution, what is state? So state means government and Parliament of India, that is executive and legislative organs of Union government. Okay, then government and legislature of state, means that is executive and legislative organs of state government. After that, all local authorities, that is municipalities, panchayats, district boards, improvement trusts, etc. After that, all other authorities, that is statutory or non-statutory authorities like LIC, ONGC, etc. Okay, so state has been defined in a wider sense. Okay, so the meaning of state for the purpose of fundamental rights is little bit different, and state is defined in a much larger way, much wider sense. Now, what is the meaning of law? Okay, so here I have mentioned that state shall not make any law. So what is the meaning of law? So the term law in Article 13 has been given a wider connotation, means it has a wider meaning. So what is law? So first meaning is permanent laws enacted by the parliament or state legislature. Okay, so what is first meaning? So first meaning is permanent laws enacted by parliament or the state legislatures. The second meaning is temporary laws like ordinances. Ordinance means ordinance issued by president or the state governors. The third meaning is statutory instruments in the nature of delegated legislation, means executive legislation like order, bylaw, rule, regulation or notification. Okay, so what is the third meaning? So third meaning is statutory instruments in the nature of delegated legislation like order, bylaw, rule, regulation, notification, etc. The fourth meaning is non-legislative source of law, means customs or uses having force of law. So customs are also included in this definition of law. So Article 13 clause 2 says that state shall not make any law that takes away or abridges one or more fundamental right. So here the meaning of state is much wider. Okay, for example, parliament is state legislature is state, union executive is state, state executive is state. Similarly, the meaning of law is also much wider. For example, customs are also included in the meaning of law. Okay, so you don't need to remember that what all includes in state and what all includes in law. You just need to understand that state shall not make any law that takes away or abridges one or more fundamental right. Okay, so what Article 13 clause 2 says, that if state makes any law which takes away one or more fundamental right or which abridges one or more fundamental rights, then that law shall be declared null and void by the Supreme Court of India to the level of inconsistency. Okay, so if state made any law which violates one or more fundamental right, then that law shall be declared null and void by the Supreme Court of India to the level of inconsistency. To the level of inconsistency means those provisions of the law shall be declared null and void which violates the fundamental right. Now friends, then comes the first Constitutional Amendment Act 1951. And what happened in first Constitutional Amendment Act 1951? That it amended the Article 15 and it introduced Article 15 Clause 4. And Article 15 Clause 4 was actually seems as a contradiction to Article 15 Clause 1. Means it was reducing the effect of Article 15 Clause 1. So it was against the spirit of Article 13 Clause 2. Then it amended Article 19 Clause 6, and by amending the Article 19 Clause 6, certain restrictions were put on Article 19 Clause 1 subclause G. Okay, so again it was reducing the effect of Article 19 Clause 1 subclause G, so it was against the spirit of Article 13 Clause 2. Now friends, what else happened in First Amendment Act? That Schedule 9 was added to the Constitution of India. Okay, and what is Schedule 9? So the laws which are included in Schedule 9, judiciary means Supreme Court has no power to do judicial review of these laws. Okay, so this was also against the spirit of Article 13 Clause 2. So what happened then? That First Amendment Act 1951, along with other things, was challenged before Supreme Court in Sankari Prasad versus Union of India case 1951. Okay, so then comes Sankari Prasad versus Union of India case 1951, and in that case First Amendment Act was challenged before Supreme Court. Now friends, but the decision of Supreme Court came in the favor of Parliament. And what Supreme Court has said, that Parliament has got two types of legislative powers. The first type of legislative power of the Parliament is ordinary legislative power. Ordinary legislative power means the Parliament has the power to make ordinary laws by simple majority. Means majority of more than 50% of the members present and voting. The second type of the legislative power, second legislative power of Parliament is constitutional legislative power under Article 368. Okay, so constitutional legislative power under Article 368. So how constitutional amendment works? Constitutional amendment works means to amend the constitution, how much majority is needed? So special majority of more than 2/3 of the members present and voting, supported by absolute majority of the house. So what Supreme Court said? So Supreme Court said that if Parliament makes use of constitutional legislative power, okay, if Parliament makes use of constitutional legislative power, means second type of legislative power, then outcome would be constitutional amendment. Okay, then outcome would be constitutional amendment and not a simple law as defined under Article 13 Clause 3. So according to Supreme Court, it is not a law, it is a constitutional amendment. So thus First Amendment Act does not come under the scope and cannot be nullified under Article 13 Clause 2. Okay, thus Parliament can amend any part of Constitution including fundamental right under Article 368. So what Supreme Court has said, that Parliament has two types of legislative powers, ordinary legislative powers and constitutional legislative powers. So if Parliament makes use of constitutional legislative power, then the outcome is a constitutional amendment and not a simple law. So Parliament can amend any part of Constitution including fundamental rights. So friends, then comes Golakhnath versus State of Punjab case 1967. So what happened in Golakhnath versus State of Punjab case? So in Golakhnath versus State of Punjab case, Supreme Court has said that Article 368 only contains the procedure to amend the Constitution. Okay, means it only has the process how to amend the Constitution, but it does not give the power to Parliament to amend the Constitution. Okay, so what Supreme Court has said in Golakhnath versus State of Punjab case, that Article 368 only has the power, or sorry, Article 368 only talks about the process of amending the Constitution, means how to amend the Constitution. So Article 368 only contains the procedure to amend the Constitution. But according to the language of Article 368, it does not confer any power to Parliament to amend the Constitution. Means Parliament do not have the power to amend the Constitution. Okay, thus Parliament can only make ordinary laws. Parliament has got only one type of legislative power. Parliament can only make ordinary laws. Parliament do not have the power to amend the Constitution. Okay, so in Golakhnath versus State of Punjab case, Supreme Court has declared that Parliament do not have the power to amend the Constitution. But then friends, Parliament responded by enacting 24th Constitutional Amendment Act 1971. So then comes the 24th Constitutional Amendment Act 1971, and according to 24th Constitutional Amendment Act 1971, Constitutional Amendment Act, 24th Constitutional Amendment Act amended the title of Article 368. And what 24th Constitutional Amendment has done, that it amended the title of 368, Article 368. So earlier, what was the title of 368? That procedure to amend the Constitution. But now the title of Article 368 became Power of Parliament to amend the Constitution and procedure therefore. Okay, power of Parliament to amend the Constitution and procedure therefore. So what does it mean? It means that power of Parliament to amend the Constitution and procedure to amend the Constitution means now Parliament got the power to amend the Constitution. Okay, so now according to the Article 368, Parliament got the power to amend the Constitution. Now friends, it inserted a new clause 4, means it inserted a new clause 4 in Article 13. So now Article 13 also had clause 4, Article 13 clause 4. So according to Article 13 clause 4, any amendment, any constitutional amendment done by the Parliament will not be seen as the law, okay, as defined in Article 13. So according to Article 13 clause 4, any amendment done by the Parliament, any constitutional amendment done by the Parliament will not be seen as law. Why? Because in Golakhnath versus State of Punjab case, Supreme Court has said that even Parliament has done constitutional amendment, but this also comes within the definition of law. Okay, so Supreme Court has said that constitutional amendment is also a type of law. So even Parliament is doing constitutional amendment, but this will also be counted as a law. Okay, but now what Parliament has done, Parliament through 24th Constitutional Amendment inserted Article 13 clause 4. And according to Article 13 clause 4, if Parliament does any constitutional amendment, including amendment in fundamental rights, then this amendment will not be counted as law, as given in the definition of Article 13. Okay. Then what happens, friend? Then comes Kesvanand Bharti versus State of Kerela case 1973. So friends, in yesterday's class, I have mistakenly told you 1773. Actually, I was thinking of Regulating Act, and in that thinking, I told you 1773, but it was wrong. So actually, it is 1973. So Kesvanand Bharti case, Kesvanand Bharti versus State of Kerala case came in 1973, and definitely it is a common sense that our constitution was enforced in 1950. Okay, and after the enforcement of the constitution, it established the Supreme Court, executive, legislature. So definitely all the things will happen after 1950. Okay, so mistakenly I have said 1773. So please correct it, and please download a fresh copy of notes from my blog, and you will also find the link of notes in the description of the video. Okay, so please download a fresh copy of the notes. So friends, Kesvanand Bharti versus State of Kerala case came in 1973. And what happened in Kesvanand Bharti versus State of Kerala case? That 24th Amendment Act was challenged before Supreme Court. So 24th Amendment Act, along with some other things, was challenged before Supreme Court. Okay. But now what Supreme Court has done, what Supreme Court did. So this time Supreme Court upheld the validity of 24th Amendment Act. Means Supreme Court has said that okay, this Amendment Act is okay. It is not unconstitutional. It is purely constitutional. So Supreme Court has said that okay, 24th Amendment Act is right. So it upheld the validity of 24th Amendment Act. Okay, and Supreme Court has said that Parliament can amend any part of Constitution including fundamental right. Okay, so what happened, that Supreme Court upheld the validity of 24th Amendment Act, and Supreme Court accepted that Parliament also has the power to amend the Constitution. So the constitutional amendment power of Parliament was restored. So now Parliament has the power to amend the Constitution, and any amendment done by Parliament in the Constitution of India will not be counted as the law. So the constitutional amendment done by the Parliament were now out of the jurisdiction of Article 13. Okay. So now as they were out of the jurisdiction of Article 13, so Supreme Court had no power to declare any constitutional amendment done by the Parliament of India as null and void. So what Supreme Court said, that okay, Parliament can amend any part of Constitution, and Parliament can also amend the fundamental right. But Supreme Court said that while amending the Constitution, Parliament should not disturb the basic structure of the Indian Constitution. Okay, so Supreme Court has said that okay, there is no problem. Parliament can amend any part of the Constitution. Parliament has the power to amend the Constitution. Parliament can even amend the fundamental rights. But while amending the Constitution, while amending the fundamental rights, Parliament should not disturb the basic structure of the Indian Constitution. Now, what is the basic structure of the Indian Constitution? Supreme Court did not tell this at that point of time, but later on in number of cases Supreme Court has mentioned about the features of the basic structure of Indian Constitution. Okay, so later on we will discuss about the basic structure of Indian Constitution in detail, but for the time being you just understand that at that point of time Supreme Court did not tell that what is the basic structure, but later on in number of cases Supreme Court slowly mentioned that these provisions comes under the basic structure of Indian Constitution. So friends, that's all for today. There is an announcement for you all. So friends, from today onwards, lecture will be uploaded on a daily basis. Okay, so you can take the lectures on a daily basis. Friends, some students are worried about the completion of their syllabus. So I want to tell that please you don't worry about the completion of the syllabus. Your syllabus will be completed on time. I will complete your syllabus on time. Okay, and you just focus on your studies, and geography will be started after the completion of Indian polity. So we will take all the subjects one by one and your syllabus will be completed on time. So please you don't worry about the completion of the syllabus, you just focus on your studies, and from today onwards your lectures will be uploaded on the daily basis. So friends, I have uploaded the link of notes in the description of the video, so you can download the links from there, and you can also download the notes directly from my blog prashant-ias.blogspot.com. You can also follow me on Instagram. My Instagram user ID is prashantias7. Friends, if you have enjoyed the lecture, please like the video, use the comment section to give your valuable feedback, share this video to all the people who are preparing for UPSC, subscribe to my channel and press the bell icon so that you get notified whenever I upload any video. Till then, take care of yourself. Thank you.